With that, I would now like to introduce to you the teams and the panel that we have here on the stage. And I apologise that I am standing in front of our panel in this manner just at the moment. But to my right, stage left, we have the team from Deakin University in Australia, who will be Claimant. And to my left, stage right, we have the National Law School of India University, Bangalore, from India. And we're very fortunate today to have a very distinguished panel with us. Chairing today's panel is Professor Dr. Johan Eru. Joining Professor Eru in the panel is Professor Dr. Ingeborg Schwenzer and Mr. Christopher Lau, SC. Before handing the session over to our chairman, I would again ask those that are entering the room to take your seats promptly and to be very careful of the place settings. Do not disturb them. One final request, please turn off your mobile phones.
Thank you, Mr. President. A very good afternoon. My name is Ashwini Vaidyanathan and I represent the Respondent Hope Hospital in this present matter. Parties to this dispute negotiated into two contracts in 2008 and 2011, which for the convenience of this tribunal, I should refer to as the Framework Agreement and the SLA. If I may directly submit on the 2 points raised by Mr. President, I will proceed to my first submission as to the validity of the arbitration agreement present in the first contract, the 2008 Framework and Sales Agreement. If I may refer your attention to page 11 of the record, the clause in question is present in Article 23, Clause 4.
May I at this stage say that we would like you to continue your argument without waiting for us when you refer to a page, because we are very familiar with the file and we are under some time pressure. You may say at which point you are citing, but otherwise just advance.
Thank you, Mr. President. If I may then directly proceed. Arbitration is fundamentally a creature of consent, and where the consent of parties to arbitrate has been compromised, the jurisdiction of this tribunal comes into question. It is true that my client, Hope Hospital, agreed in principle to arbitrate disputes arising. What Clause 4 requires the application of, however, is the Danubian International Arbitration Act, as that is what parties have agreed upon.
And counsel for Respondent, before moving back to consider the effect of Article 23, Sub-Article 4. In relation to counsel for Respondent's submissions regarding the necessity of an arbitration agreement to be mandatory, it is counsel for Claimant's submission that although this was traditionally held to be the case, the trend in modern era has been to allow parties, by exercise of their autonomy, to determine whether arbitration or litigation is the correct course for the resolution of their disputes. And in this vein, the learned author Gary Bourne, in his 2013 text on drafting arbitration clauses, notes that specific carve-outs for aspects of a dispute that may arise that would need to be resolved quickly or may run into enforceability issues, such as, in claimant submission, payment claims, are able to be subject to litigation rather than to arbitration. With regards to the cases suggested by counsel for Respondent that where an option to arbitrate or to litigate exists, the arbitration must read may arbitrate or may litigate, counsel for Claimant would note that under Article 20, in addressing the meaning of this provision, counsel for Respondent directed this tribunal first to Circular 265 on page 36, Respondent's Exhibit number 1. Claimant would ask this tribunal to note that that document, as noted by counsel for Respondent, provides that government entities must not forego the right to review manifestly erroneous decisions. And Claimant would further note that review has a very specific and defined legal meaning. It means a review of the process by which an award was rendered in accordance with the Article 34 model law grounds as adopted in Danubia as the international arbitration law. As Respondent noticed, this shaped Respondent's agreement and consent to arbitration, and the counsel for Claimant would further distinguish Respondent's submissions with regards to the cases of Galloway, Cook, Allen and Carr, and Hall Street and Mattel. In both of those cases, what the parties contracted for were clauses which said that the parties may... on this matter, it would be counsel for Claimant's submission that while this tribunal is empowered to determine its own jurisdiction, it is not empowered to determine the jurisdiction of the courts, and that if this clause is found to be an appeal and review mechanism, rather than being read as the words stand, as a review mechanism, providing the parties with the ability to feel an award is obviously wrong, and then the state courts the ability to review, that this tribunal would not be able to sever parts of the clause, but would rather have to consider whether the clause stood as a whole or fell as a whole, and then whether, in falling, Article 23, Sub-Article 4 would take...
For both sides, we never really discussed the legal basis upon which this tribunal is going to decide which law applies. Could you briefly elaborate on this question, very briefly, before we turn to the other points, please?
This contract.
So, is it your position that this tribunal is bound to apply the CISG if the parties did not validly opt out from it?
It is our position that the CISG should be found to be presumptively valid and applicable, as both parties are contracting states from different contracting states to the CISG, and unless an exclusion of the CISG is found to apply,
it is inapplicable to governing service contracts. In this contract, based on the subject matter of the SLA and the breakup of the software component, we argue.
May I just ask you the question, if we were to come to the conclusion that the CISG in principle could be applied, would that mean that this tribunal is bound to apply the CISG?
No, Madam Arbitrator. The CISG applies in principle to determining the issue on incorporation of standard terms, because provisions Article 14 to 19 of the CISG.
I think we certainly will come to that point to ask you your position on that, but there seems to be a question that precedes that one by some legal length, and what arbitrator Schwenzer is asking.
Incorporated into this contract. Whether the CISG is applicable is determined on what choice of law clause might be applicable to a contract, and this in turn depends on the set of standard terms and conditions applicable under the sales and licensing agreement. On page 20 of the record, Article 46 of the sales and licensing agreement refers to the seller's standard terms and conditions.
Both ways. Your client is in a negotiation using the English language. So what would you say about language risk if you do not communicate new standard conditions in the English language, which seems to be the language of the contractual relationship, isn't it?
Members of the tribunal, indeed the contractual relationship between the parties was in English. However, I would go back to an earlier submission on it.
If the parties agree on the law of a member state, then the CISG is included indeed. But all of these cases were contracts that were entered between parties for the first time. Don't we have a different situation here where we are
addressing this tribunal in my native tongue? The tribunal would understand me. Opposing counsel's client had provided us a copy of the revised standard terms in a language that we do not understand. Before I begin, however, what I will state at the outset is what I'm not contesting. And what I'm not contesting is that a reference has been made to the revised standard terms. It is clear from the facts on record that a reference has been made to the revised standard terms. However, the CISG Advisory Council opinion number, even if it did make a difference, under the issue of standard terms, it would be excluded. So even if it is a contract for the sale of goods, because the revised standard terms are not incorporated, and because the revised choice of law clause does not lead to the application of the CISG would anyway be excluded. Hence the reference to a pack of cards from which I pull out one.
Okay, I understand, and we will give Claimant some opportunity to come back to the issue that has in this manner been introduced. So you do say that if the parties had been contemplating another contract that would have been less associated or could be less associated.
Distinction between the submission that we are making and the kind of software that we ordinarily see. Everything that we use has a software element to it nowadays. From the car that we drive to the iPhone that we use, everything has a software element. In those cases, it is not our contention that it fails to constitute a good under this
Particular obligations under this contract. We're going to the production of what was contracted for here. The contract provides on page 18 that this was a third treatment room with active scanning technology. Prior to the conclusion of this contract, there was no active scanning technology. This room that was constructed was then installed with basic software, following from which this testing and fine-tuning took place. At the end of all that, there was this third treatment room with active scanning technology.
Paragraph 2. If I may use a brief analogy, if we would go to a ready-made shop to buy a suit, it is a good. If I go to a tailor shop and ask him to stitch a suit, it is a service. The fact that I'm finally getting a suit will do nothing towards characterizing this service as a good. Thank you very much.
Thank you. And I don't think we will expand on the suit and the stitching of the suit, because that would get us into Article 3.1 again, I'm afraid. We need to conclude the oral hearings of today. I will not declare the proceedings closed in their entirety, because you know that the case continues. But I thank you today for the argument that you have brought to us, and that concludes this part of the arbitration proceedings. Thank you very much.